ruling on the application of F and another against the Secretary of State for the Home Department.
My Lord, my Lady, good morning. Can I introduce who's here before you this morning? I'm leading Jeremy Johnson for the Secretary of State. F is represented by Mr Southey and Mr Straw. Thompson is represented by Mr Owen and Mr Weatherby. We're lucky to have representatives from the Scottish Bar here as well. The Lord Advocate is represented by Lord Boyd of Duncansby and James Muir. And A, as in A and the Scottish Minister, the case you may have seen in the bundle, is represented by Mr O'Neill, who's leading Mr Pirrie. My Lord, my Lady, may I start very briefly with the skeletal facts, as it were, of both of these cases. Just before coming to that, I should say that before the court entered, I was told that there was floating around somewhere, I haven't seen it, but a separate reporting restriction on the name of F that I think has emanated from the court. We, for our part, certainly have no objection to such an order being made, and I understand from Mr Southey that he would wish such an order to be made. I don't know if there's going to be controversy about that, but for our part, we're content.
Yes, well, the identity of F is not to be disclosed.
I'm grateful. Lord, my Lady, can I start with the facts then of F? F was born on the 11th of November 1992. The relevant offences were committed between May and the end of September 1994, as one sees from the bundle in appendix at page 190. At the date of the offences, he was 11. He was convicted on the 26th of August 2005. He was convicted of 2 offences of anal rape of a child under 13. The victim was described in the sentencing remarks of the learned judge as being utterly innocent. That's appendix page 177. And he was a little boy who was age 6 at the time. He was also convicted of 4 offences of other sexual activity with the same child, described again by the learned judge in sentencing appendix page 176 as being, quote, almost as serious as the 2 offences of rape. The child in question, the victim, lived next door to F. And again on sentencing, the learned judge, appendix page 177, concluded that there was, and I quote, a strong element of bullying and humiliation of this little boy. On the 17th of October 2005, F was sentenced. The sentence was one of 30 months detention under section 91 of the Powers of Criminal Courts, brackets Sentencing Act 2000. He was sentenced to 30 months on each of the offences to run concurrently. On the 2nd of February 2006, his appeal against sentence was dismissed. On either the 15th or the 16th, it's not entirely clear, there are 2 different dates in the appendix at page 195 and appendix page 63, but either the 15th or the 16th of January 2007, he was released on licence. On the 15th of April 2008, the licence expired, as one sees from appendix page 183. A little under a year later, his case was referred back to the Court of Appeal by the Criminal Cases Review Commission in relation to sentence. And that further appeal against sentence was then dismissed on the 27th of January 2009 by Lord Justice Latham. There are in the appendix, as I'm sure you will have seen, between pages 183 and 196, a number of reports on F, most of which I think post-date the release from prison. it may just be worth turning those up because it requires a little detective work to try and work out the dates of them. And it may be convenient if I assist by trying to give what I think are the relevant dates. In the appendix, page 183, you'll see the date stamp of July 2008, and it appears that that report was prepared at least around about that date, July 2008. You'll see in paragraph 3 that there is reference in the second sentence to the final moving on report. That, for your notes, is at page 185 of the bundle. And you'll see the conclusion which is reached at that stage in relation to F, which is that he's medium to low risk to children in the community. That remained the risk assessment throughout the relevant period. That is, as it were, the latest risk assessment that one has on him. Page 185 then is the moving on report.
Can you just pause there? Is risk to children in the community? That's the way it's phrased.
It is.
It wasn't forward-looking particularly, but that's the present state of affairs.
That's the present state of affairs. We understand that there is no further follow-up report of which I'm aware, which post-dates July 2008. The moving on report at page 185, in effect, is a summary of a programme involving F that ran between March and April 2007. So it was post-release. It's not entirely clear precisely what date this report was prepared, but as I say, the best indication one gets from it is that it was a summary of a programme in that period, so it's probably sometime shortly after, but certainly after, August 2008, August 2007. And page 189, the illegible title at the top is a comprehensive assessment report, and that is dated March 2007. Those are the dates of those reports, and those are the only reports one has in the bundles before the court on F.
Yes, Mr. Eady, the facts of this particular case,
Yes.
while illustrative of the effect of the legislation, are presumably no more than that so far as relevance is concerned. We're concerned with the principle.
My Lord, I entirely accept that, but I thought it was nevertheless helpful to try to give, at least in summary form, the illustrative facts. But I accept that proposition. The challenge is to the legislation, as my Lord and my Lady are well aware. And that point, at least I hope, serves to excuse the paucity of facts that one has in relation to the second case, illustrative case, which is Thompson, who was an adult. The only facts, as far as I can tell, that one has in relation to him is that he was sentenced on the 12th of December 1996, so prior to the original 1997 Sexual Offences Act regime coming into force. He was sentenced to 5 years imprisonment for 2 counts of indecent assault on his daughter. And the only other fact that we have in relation to him is that he was released on licence on the 10th of April 2000. We have tried, if only for illustrative purposes, to get hold of at least the sentencing remarks in relation to Thompson, but I'm afraid without success. But given the point that my Lord Phillips made, it may not matter terribly. My Lords, my Ladies, so those are the illustrative facts. May I then turn to the legislative regime and start that with an apology. And the apology is that in the appendix, my lady, the apology comes right at the outset. In the appendix, the act is not the act you should be working on, and I'm afraid it's extremely unhelpful for you if you have been working on that, but That is because various changes were made to it, and there is a complication about what does and doesn't apply to Scotland. So this is one of those pieces of legislation where I'm afraid you do need the helpful notes that feature in the electronic version of the relevant legislation that you have in Bundle 8 at tab 68. So I was proposing to work off that if it was convenient for the purpose of this introduction. Part 2 of the legislation commences on numbered page 79, using the numbers at the bottom of the...
Is the analysis in your case correct? The version, rather, in the case.
I will double check that. I think so, and I hope so, but I will double check that. If there are corrections or additions that need to be made, we'll alert the court to that. So page 79, you'll see part 2, which is the relevant part. This is the Sexual Offences Act 2003. In terms of its application to those who are convicted and become subject to the notification requirements, one can, for our purposes, note that you can become subject to the notification requirements through effectively 2 different routes. The first is if you are convicted of an offence of a type listed in Schedule 3 after the commencement of the relevant provisions of Part 2. And those provisions commenced on the 1st of May 2004. I think they commenced for that purpose, both in relation to Scotland and in relation to England, Wales and Northern Ireland. The commencement of Part 2, the order bringing it into effect, is, for your notes, in Bundle 8, tab 76. We perhaps don't need to turn it up. But the first way in which you become subject to the regime, you will see set out in Section 80, subsection 1A. Are you convicted of an offence in Schedule 3 after the commencement of that part? The second way in which this regime can apply to you is if you were convicted of an offence in Schedule 3 before commencement. That is in Section 81, 1A. There is a rider to that, which is in Section 81, subsection 3, and in particular subsection 3B. In order for the Act to be applicable to you through this route, you've got not merely to have been convicted before commencement of an offence in Schedule 3, but you also must have been, relevant for our purposes, serving a sentence of imprisonment on the 1st of September 2007.
Well, the point is to people like the second respondent,
Yes.
Who were convicted of offences before there was any legislation of this sort at all, presumably.
Well, it bounces in 2 stages, because first of all, he was convicted before even the 1997
Yes.
regime came
Well, that's
into
what
play.
subsection 3
Yes, exactly.
refers to.
Exactly.
Yeah.
My lady, you're right. Schedule 3, the relevant paragraphs to note, Schedule 3 commences on page 158. And so far as our illustrative cases are concerned, the relevant paragraphs in relation to F are paragraphs 19 and 20, which you see on page 160. And in relation to Thompson, the relevant paragraph is paragraph 7 on page 158. So if you fall within those provisions, the Act is applicable to you, and it's applicable to you as the offender. It is perhaps worth noting in relation to young offenders, the provision in section 89 of this Act far as I can tell, was not operated in relation to this young offender, no doubt because it was thought unnecessary to do so, but that permits the court, that empowers the sentencing court in the first instance to impose obligations on an adult responsible for the child or a parent.
Sorry, where is that?
Section 89 is at page 92. And the power which is open to the sentencing court, you will see in 89 subsection 1, and the first set of boxes in the table within 89.1. So, for example, in relation to F's case, he was a relevant offender within 80 subsection 1, subsection A, because he was convicted of an offence listed in Schedule 3 after the commencement. And the court which can make the direction is the court which deals with the offender in respect of the offence or finding. So that's a power, first of all, open to the sentencing court. It's also a power which is open to magistrates after sentencing and after release, presumably, by virtue of section 89, subsection 4, on the application of the police. As I say, it doesn't apply in F's case, but it is perhaps worth noting under the heading of application of the Act, it can apply either to the offender, him or herself, or by virtue of these provisions to a parent. So going back then, if...
That's instead of the child, is it?
It's instead of the child, I think. Yes. Subsection 2A, 89 2A.
It can't be both.
I don't think it can be both. It says instead
It
of.
says instead.
It's instead of in 82. Sorry, in 89 2A.
But that's the obligations in 83 to 86.
Yeah, but they are the ones.
Notification requirement.
Then the notification period, the set of provisions which deal with the length of the period, next, if I may.
So how does it convert to what happens when the child becomes an adult? I mean, what are the requirements, the notification requirements? Do they move over in some way?
In subsection 3, it
Sorry.
says it applies until the offender reaches the age of 18.
Yeah. So it then reverts.
Presumably it is intended then to revert, although I think my Lord Rogers' point maybe, well, how does that sit with the instead of provision in 2A? But as I understand it, the intention is it would then revert and they would then be responsible for
I can imagine it must be intended. I just wondered whether there was a mechanism which did it.
I think the only relevant one is 3A. The Act would continue to apply to the young offender.
It's the direction is made under subsection 1, isn't it? And and that brings in subsection 2 because that's what the direction says.
Yeah.
And then subsection 3 tells you, in effect, that the direction ceases to have effect, either at such time the court specifies or at that age.
Exactly, but at that point, section 81A would continue to apply to the offender.
Right.
Is presumably
Yes.
the way it works.
Yeah. I see.
Well, maybe.
The notification period, then, there are varying periods set out. Both section 80 subsection 1 and section 81 subsection 1 refer on to section 82, and 82 on page 81 of this little clip is the relevant table setting out for how long people are subject to the notification regime.
The expression indefinite period means until death.
It means until death.
Do we know why it was framed in that way? I was slightly surprised.
Why it was framed as a...
Why it didn't say for life or something like that? I mean, why did they say indefinite period? It struck me as a slightly strange expression.
It's a definite period, it's just one doesn't know when the death is going to be.
Yes, I think it was perhaps phrased in that way, drawing a contrast between the finite periods that are set out in the rest of the table, but
It's slightly inaccurate to describe it as indefinite.
because plainly it would be terminated by death. Yes, well, that's a fair point, but I think that subject to that long...
I mean, it's a life sentence.
It is. A number of points perhaps to note in relation to the table. The periods, as one sees from the...
So it does mean that. I mean, it can't be, you know, until the until the king dies or something like that, which would be an indefinite period. I mean, it means life, doesn't it?
It means life.
It's not any indefinite. You can't specify. It doesn't specify any other indefinite period.
No, it specifies no other endpoint. You'll see that the periods are set by Parliament by reference to the seriousness of the offence as reflected in the seriousness of the sentence. That is the basic structure of the table.
So we get 29 months, so 10 years, we get 30 months of life.
That is correct. There is a bright line rule being, or is a bright line being drawn. So there are some where you're a day behind and a day on the other side. That was right. But it's only for the most serious offences, i.e. those for which the sentence is over 30 months, where the indefinite period is prescribed. And it's perhaps worth noting in relation to that little box dealing with the term of 30 months or more, that section 131H which is at page 139 of this little clip, extends, as it were, the concept of imprisonment to include the sort of detention that was ordered by the court in this case, 131H. You'll see refers to a sentence of detention under section 91 of the Powers of Criminal Court Sentencing Act 2000. And that needs to be read with the final two lines of that section.
It is very strange that if you go back to the box on page 81, or the two boxes, that the left-hand box talks about imprisonment for life, and in the second one down, order for lifelong restriction. You've got all the labels that you might like to use if you're really describing what indefinite meant by reference to life, and it isn't carried across into the right-hand boxes. But anyway, you accept that that's in effect what these words mean, and we must take it on that basis.
Oh, I do. Mm-hmm. But it applies for life.
And does that mean that nobody has any power to vary the order? Whatever happens, neither the police nor the state nor anyone has any power whatever. Even if you were in a persistent vegetative state, there would still be no power to vary. Is that right?
Oh, that is our understanding of what Parliament intended. It sets the periods. It set the periods of the finite periods of years, and it set the indefinite periods so that it applies for life.
So Parliament never contemplated the kind of example that Lord Clark has referred to.
Well, Parliament plainly did contemplate the possibility of, it appears from the academic article, which appears at the very back of bundle 11, it did contemplate the possibility of a review or appeal, because there was a clause that was sought to be introduced during the passage of the bill, introducing precisely such an appeal or review, and that was not accepted by the government and was then withdrawn. So Parliament did consider and specifically considered whether there should be a general power of appeal or review, and rejected that.
And I don't know whether this is a relevant question or not, but is there any indication of the evidence that Parliament had when it reached these conclusions? First of all, is that a relevant question? And secondly, if the answer is yes, what's the answer?
Well, my Lord, we don't entirely know what evidence Parliament had before it, other than it was debated at some length. And there are references in the judgment of Lord Turnbull in A and the Scottish Ministers, a variety of references to Hansard. We don't have the Hansard references, so we don't have the underlying Hansard extracts in the bundle. So I'm afraid I'm not at the moment able to assist on the precise extent of evidence that Parliament had before it, other than by reference to the description of the Hansard extracts considered for the purpose of that case in Scotland, which are summarised at some little length, at least, in the judgment of Lord Turnbull in A and Scottish Ministers.
It makes the court's task quite difficult, doesn't it, when one's looking at proportionality in relation to these regulations, and dealing with arguments as to resource implications if there were a possibility of review, dealing with proposition that once a sex offender, always a sex offender.
My Lord, one has a little bit more in relation to the latter question,
Yes.
because you will have seen in the appendix that there is at least some material relating to that. There was more material at first instance, in the sense, I think primarily, that there were a series of reports that were appended to Jenny Cann's witness statement, which ran to a bundle and a half. But the parties have got their heads together, and the extracts you have are fairly representative of the material on that issue, which I will have to come to. There isn't, I think, anywhere in the bundle anything directly going to the precise nature and extent of the resource issue, but it may be that that is an issue which is one where the ultimate answer, is there going to be a significant resource implication, is relatively obvious, and that obvious answer is perhaps less important than the precise detail of it. I say that because you will have seen a variety of figures. I'll come back to give you the precise figures in a moment, but there are references, I think, in the material, and I'll give you the references in a bit, to the numbers of people who are subject to the various regimes, to the indefinite notification regime. Certainly at December 2008, I've got up-to-date figures in relation to that, but it's roughly 20,000 people, perhaps a little over, and it might be thought in those circumstances that the resource implication of introducing a right of review or a power of appeal or something of that kind was relatively clear from that number alone. And the court could make its own assessment of the extent of that resource implication from the number.
I just wonder, Mr. Eady, I mean, I see we have in volume 2, tab 14, Wilson and the First County Trust case, and that was, and this point sort of arose in that, and one finds at page 843, paragraph 67, I think, where Lord Nichols deals with the question as to whether or not, in considering proportionality, one has regard to the quality, so to speak, of the discussion or the evidence available to Parliament. And I think that, I can't remember whether other people dealt with the same point, but I think that...
That is the legal yardstick, as it were, the legal test.
I think that's where one, I think...
Yes.
At least that's, I know that was discussed in that passage.
My Lord, you recall right, that certainly is the position. Maybe that's the answer to... Well, that is the answer to my Lord Clark's question. Is it relevant? The legal test is there. But as I say, you will
So
have...
is it relevant or irrelevant to know what it was that Parliament had before it? I mean, I quite follow that it's irrelevant whether what any individual member thought or and so on. But I seem to remember, I've certainly been involved in cases where there's been a good deal of evidence.
The courts were presuming to evaluate the sufficiency of the legislative process. I think Lord Nichols was rather against that approach. And that's my recollection.
Yes, and my Lord, there was, as I say...
I mean, for example, in the hunting litigation, there was a good deal of material about what was before Parliament, and we had a case about smoking smoking ban in the Court of Appeal, this is, smoking ban in hospitals like Rampton, and again there was a good deal of material before the court of what was before Parliament. I don't think anybody ever suggested that it was inadmissible. Quite what use you make of it is another question.
Yes.
But these are quite important questions, actually, in this sort of case.
My Lord, yes. I mean, the difficulty I have is that certainly at first instance and in the Court of Appeal in our context, precious little, if any, reference appears to have been made to Hansard.
Right.
We haven't got before the court, I'm sure we could get it, we haven't got before the court at the moment all the Hansard extracts that might be of relevance, although you will have seen from and the Scottish ministers and the report of that case that there was consideration of, for a variety of different purposes, of some of the relevant Hansard extracts in that. If the court does consider it important, I'm sure we could pull together the relevant extracts and material. I think some steps towards that end have already been taken by the Lord Advocate, so it may be that...
My recollection, Mr. Easy, I mean, again, is that the general approach is the question of the proportionality of the legislation is judged at the time that the issue arises. And so the question is it proportionate as it applies today and so on?
Yes.
Not. And so for that reason, I haven't reread it, so I may be doing an injustice to Lord Nichols, but his general approach was you look at the situation today, is it proportionate? Yeah. Rather than doing an excavation of the reasons which were behind the Parliament's decision at the time when it introduced the legislation. And that is my general recollection. I don't know whether anyone...
Indeed, there's a caveat on having regard to parliamentary material in the context of an issue of proportionality, as opposed to simply background or mischief.
Well, there's a little bit at page 857, paragraph 117, 118, where I was venturing into this area and drawing a distinction between looking at the material simply for information as opposed to questioning the proceedings in Parliament on proportionality grounds. And so it's a fairly cautious approach, but the information which Parliament may have been given may be helpful to some extent in understanding what it was addressing.
I mean, this whole question is relevant, perhaps, to the margin of appreciation, if that's the right expression, or the deference which one's given to Parliament. Because,
Well, that's the point, isn't it? A lot of the information that may or may not have been before Parliament may be relevant to the court's consideration of what is and is not proportionate. So there might be a big overlap, there might not be a big overlap. Depends. Parliament may not have been given this information, whereas we may be, which enables us to make a judgment about it. But the less Parliament knew about it, the less weight one might be inclined to give to the fact that it was a judgment made by Parliament.
Precisely.
I think that's the point you're making, isn't it? Yeah.
Well, I'm going to come on to the extent of deference, and for that purpose I'm going to take you to bits in the case I keep referring to, which is and Scottish ministers, which is the limit of what was and wasn't before them. But there has been some analysis of that. Just before one leaves Wilson and First County Trust, at least in the speech of Lord Nichols, my attention was drawn rightly to paragraph 67. It may also be worth putting a line next door to paragraph 64 in his speech, which appears to touch on the same issue and is perhaps a little less cautious, a little more permissive.
Yes, I mean, that's the point I think I was picking up, really, exactly. This difference between questioning what Parliament was doing and just simply looking to see what information Parliament had before it.
Well, that was what put me in mind of 64, and took me to 117 and 118.
But I mean, he says it, H, lack of cogent justification in the course of parliamentary debate is not a matter which counts against the legislation on issues of proportionality. That's what is his approach.
Well, we can certainly, in the light of this helpful discussion, we can certainly revisit the issue whether there is additional material which should be put before the court, particularly given that I suspect that a large chunk of that has been collated already for the purpose of and Scottish ministers, and if it is of some assistance, I'm sure we can do that with a short covering note. Now, Lords, my lady, going back to the legislative regime then, you will have seen that some consideration expressly is given on the face of the legislation in 82 subsection 2 on page 82 to the position of young offenders. i.e. those who are under 18 on the relevant date, which is the date of conviction, because the finite periods at least are halved in that case. And again, I'm going to come back to this point, but in relation to the indefinite period, which stands by way of contrast, my understanding at least is that in any event, in sentencing a young offender, the court would pay heavy regard to the fact that they were a young offender, and therefore, to put the point shortly, if a young offender gets a sentence of 30 months detention, that offence is of both considerable seriousness and probably greater seriousness than would attract an equivalent sentence of an adult.
Which merely underlines the question mark I had as to the thinking behind halving the period in relation to young offenders. So your submission would suggest that when one's relating the danger that they posed to the sentence, and therefore implicitly the conduct in relation to which they're being sentencing, the same sentence is going to be indicative of considerably more serious conduct on the face of it in the case of a young offender.
Well, that's a fair point, but it may be that there are balances to be struck on those sorts of decisions, particularly bearing in mind points which we'll have to come back to, as to the nature of young offenders, if I can put it that way.
So the bright line between 29 and 30 months is between 5 years and life, not 10 years and life.
Yes, in the case of a young offender, that's right.
Now, would it be a relevant consideration for the sentencing judge in deciding whether to sentence for 30 months or 27 months? It wouldn't.
No. There's clear authority to the effect, I think that was Longworthy amongst others, but there's clear authority to the effect that this regime is not relevant to sentencing. It's a separate regime. It applies for different purposes. It's not punitive. It applies for protective purposes.
Well, that's clearly understood, but I mean, that doesn't mean to say it might not be a factor in a judge's mind. I mean, there is authority that he should exclude this from his mind, is there?
I'll have to check whether it goes that far.
Did the CCRB send the case back because of the reporting implications, in which case that issue would have been fairly and squarely before the Court of Appeal when it came back?
They did, and then the Court of Appeal concluded that the two exercises were essentially separate and the sentence wasn't manifestly excessive.
Yeah.
So did they say it was irrelevant? It shouldn't have been sent back because on that footing it would be an irrelevant circumstance.
No, I'm not sure they went that far.
So it is relevant then?
Well, my lord, as I read the authority,
Well, it's either relevant or irrelevant.
It isn't relevant. It is our understanding of the position.
And some might think it's a bit startling that it be wholly irrelevant, I must say. But,
well,
I suppose it would be very obvious if the sentence was 29 and a half months. The judge was trying to avoid this regime, but one
it's a
doesn't
bit
get
like
that
the
kind of
4-year line between a short sentence and a long sentence. A short-term sentence and a long-term sentence. If you get 4 years, you had to do X. If you've got 3 years and 9 months, which is quite common in practice, you get you only have to do a fraction of X. Now, I don't know whether that's relevant or irrelevant or not either.
and I don't think Lord Justice Latham's judgment on the CCRC application is in the bundle, but we can certainly get that as well. It's a relatively short judgment, which will illustrate how he approached it. Then the notification requirements themselves, they commence in section 83. And so far as F is concerned, the relevant provision is 83.1, imposing an obligation on him to notify of the various information within 3 days of conviction. But you'll note in relation to 83.1 that it's to be read with 83 subsection 6, which effectively excludes, requires to be disregarded any time that the offender is in custody or serving a sentence of imprisonment.
It's the sentencing court, is it, which decides whether to impose these requirements on the parent rather than the offender under
It's the
section.
sentencing court which has that power under Section 89. The provisions will, leaving aside that power, the provisions will apply automatically.
So it's not entirely an administrative matter because it's part of the sentence.
It isn't in that respect, in relation to extending it to apply to parents.
No, not extending it, but substituting the parent for the offender until the age of 18.
Well, yes, that plainly is a power in the court. But otherwise, the
As part of the sentencing process.
well, it's a power conferred on the court which has carriage of that. So, in that sense, yes. The court which deals with the offender in respect of the offence is the second box. So there's an initial notification within 3 days, subject to being in custody. And in relation to those who were convicted prior to the commencement of this Act, but there is no need to re-notify initially on the commencement of the Act. That is Section 83, subsection 3. Assuming it seems likely that he complied with the previous regime. The nature of the information is then dealt with in Section 83, subsection 5. And the position here is that in relation to England, Wales and Northern Ireland, there is nothing prescribed. And so the information, the nature of the information which must be given is as set out on the face of the primary legislation. In relation to Scotland, however, the position is different. And you will see, if you turn to the next tab, if you would, tab 69 in this bundle, that the relevant provisions of the primary legislation are different. See, in particular, if you go to the next tab, the page numbers are at the top of the page. On page 2, down in footnote 5, you will see Section 83 recreated, but in the Scottish version. And the principal differences.
How does this work? How does it get changed into this version?
By the Scottish Parliament, they make this provision. It's added by, see footnote 6.
Added by, yes, I see.
Which is the relevant Scottish Act in 2006, which creates this section as it applies in Scotland. And the relevant differences for our purposes are in relation to H, 83.5, H and I on numbered page 3.
Sorry, where are we?
I'm sorry, tab 69.
69.
Footnote 5, which sets out Section 83 as it applies in Scotland.
Yeah.
And we're within subsection 5, and within that we're paragraphs H and I.
Oh, yes.
Which are different from the version that applies that we just saw in relation to England, Wales and Northern Ireland. So you'll see in substance, what has happened is that in Scotland there is a requirement for details of passports to be given. See subsection H. And it's also to be noted that the power to prescribe in Scottish ministers, to prescribe in regulations, additional information has been exercised in Scotland. and those regulations are in bundle 9 at tab 84. And the relevant regulation is regulation, for our purposes now, is regulation 3.
Sorry, which tab?
Tab, it's in the next bundle entirely,
Yes.
bundle 9, tab 84. Tab 84, and the relevant regulation is regulation 3 on page 2, page numbers on the top.
Did the 2003 Act apply to Scotland originally, did it?
Yes, it did. I think Scottish ministers consented to the UK Parliament legislating for all of them, and then there was something of a change of heart in 2006, which led to the to the provision I've just taken you to. And so you'll see from Regulation 3 that in Scotland, and this is the substance of it, in Scotland, but not in England, Wales and Northern Ireland, the nature of the information that has to be provided includes details of passports and includes a variety of financial information, bank accounts, credit cards, debit cards, in summary.
What's the purpose of that?
Well, I think that I was discussing this with the Lord Advocates. I think this flowed out of the concerns about people downloading pornography from the internet. There was a major police investigation, which I think was a UK-wide investigation, but Scottish ministers decided as a result that they wished for monitoring purposes to have this information as well.
So none of this has a parallel in England and Wales or Northern Ireland?
I would know. So there is a discrepancy, a difference between the regimes in that respect. And I'll going back then, if I may, to the previous bundle to pick up the regime. That's highlighted that difference in relation to Scotland. Back into bundle 8, tab 68.
They don't look like a mere inconvenience to me, those regulations, I must
Those
say.
are rather more onerous.
We were within section 83, subsection 5. And perhaps simply to note, because this is the first time we've come across regulations being made by order, just for your note, section 138, which I'm afraid rather unhelpfully is not in the bundle, but perhaps you just simply need to note it. Section 1382 provides for the manner in which such regulations are to be made. In summary, any such orders have got to be made by the affirmative resolution procedure, so they've got to be laid before and approved by both Houses of Parliament. So any regulations of this kind extending, for example, the nature of the information, section 1382 says they've got to be laid before and approved by resolution.
I don't think, I can't find it. Where is it?
I'm afraid it's not in the, I'm afraid typically it ends at 137.
Okay.
So that's in the original statute, is it? Or
That's in the original statute.
and 138?
138 subsection 2.
Right.
It's in the original statute, but subsection 5, capital A, was that in the original statute?
No, that was introduced.
I mean, the prescribed information, little h, was that in the original statute?
I'm just checking.
No, it doesn't look like it because they're brackets.
Yeah, 2008 Act, I think. You see over the page, under amendment, about 6 lines down over on page 85, subsection 5, paragraph H, inserted by the Criminal Justice and Immigration Act 2008.
But Section 138,
Section 138, I think, was always in the
well, in relation to a power that did exist or didn't exist.
I think it was a general power. There are other provisions in this Act which refer to the making of orders and regulations.
There'll be lots and lots, I should think.
There are lots and lots, and so it was a general power to make orders in that particular way. Just double checking that. Yes, and looking at what, my version of 138, the affirmative resolution procedure is for any order or regulations made under Section 21, which we don't need to concern with, or any of Sections 83 to 86. That's Section 138, subsection 2. It's still on the content of the information which has to be provided. Perhaps worth skipping ahead a little bit to look at Section 86. So that's the basic information is in 83.5 and regulations made under it, of which the only regulations have been in Scotland. Section 86 deals with travel. And you'll see that that is one of the provisions where regulations can be made, and they have been made. In essence, it is covering, as you see in 86.1a and b, a requirement to give information both before they leave and if they subsequently return. Two lots of regulations have been made in relation to this.
These apply to everybody, including children.
These apply to everyone, including children. They apply to everyone to whom the regime is applicable. Two lots of regulations have been made in relation to this. The English, England, Wales and Northern Ireland regulations are at Bundle 8, tab 77. And the Scots regulations, which are essentially to the same effect, are at Bundle 9, tab 87. So English ones are at 877, Scottish ones are at 987. And it may just be worth turning up the English ones, because I don't think there's any significant difference between the two. So the same bundle, tab 77.
How does this work? When you look at number 7, for example, if your flight is cancelled and on your rescheduled, you would have to tell them what the rescheduled date was for your altered flight, would you?
Yes, there are provisions which govern what you have to what you have to provide and how you have to do it. The relevant regulation before leaving the United Kingdom is Regulation 5.
Yes, well, again, these, in a way, are illustrative, aren't they? Because if the regulations were objectionable, we could strike those out, strike them down. But we're concerned with the statute as to whether the statute is...
My Lord, you are. The only reason I'm
Yes.
taking you to them is because you'll appreciate that under any proportionality exercise, it is at least relevant to have regard to the nature and extent of the interference with the human right. And both the courts below place some reliance upon the existence of these travel notifications.
Yes, well, they're illustrative of the kind of regulations that are
That could be
necessarily going to be put in place to give effect to the statute, that their precise details, again, are not directly relevant.
Well, other than in the way
Yes.
that I've indicated,
Yes.
they could, of course, be changed by order if it was approved
Yes.
by a resolution made before.
But if we said there's nothing wrong with the Act, if only sensible regulations had been drawn up, we could simply strike out the regulations.
My Lord, you could. given, there wouldn't be any difficulty with that.
I'm just imagining these 12-year-old boys making these fishing about the regulations, saying, "Oh well, I've got to go," and it's all very bizarre.
Parent, I presumably would do that.
Well, my lord, it applies as
It
information.
applies to the 11-year-old boy as to anybody else.
It does.
And Section 87 tells me he's got to go to the local police station every time. I mean, is that right? I mean, again, the example of him being told his flight has been delayed until tomorrow, he'd have to go to the police station and tell them that, would he?
That is in relation to the manner in which the information has got to be given. That is right.
So he can't use his mobile.
He can't use his mobile
personal attendance.
to ring in. I
Presumably,
think I'm right in saying that is one of the differences. That's not a significant difference, but I think the Scottish regulations deal specifically at their end with the manner in which the information covered by these regulations is to be given.
Yes.
But I think that is by reference back to Section 87 and its provisions. So, but the English ones don't do that, and therefore the manner in which the information is to be notified is that set out in the primary legislation.
Yes.
But in summary, in relation to England at least, in terms of the content of the travel information, the position is this, that if you intend to leave the United Kingdom for 3 days or longer, you've got to give notification of that. And the notification has got to be given 7 days before, or at latest 24 hours before, if you don't know the information that far in advance.
and if you were a boy of 12, presumably the direction would have been made to apply to your parents, and therefore they would make the notification. Is that right?
That is the way it could work.
It could work.
Or alternatively, the parents ensure that that is the regime that does apply
Yes,
to
but
the
the
child.
obligation as applied to F were all on F.
Yes, they were.
And he's the person who commits the offence if he doesn't go in person to the police station in relation to each of these regulations.
I thought, I mean, so I'm just clarifying, when you make a direction under 89, a parental direction, the obligations, it seems to me, of notification and so on, which apart from this subsection will be imposed on the young offender, are treated instead as obligations on the parent. So if the young offender would otherwise have to notify his travel plans, would it not be for the parent to do it? I mean, I just
Well,
asked.
if such an order was made,
Yes,
my
well,
lord
if-
will have seen that the Section 89 does not automatically
No,
follow.
I'm not suggesting it does.
And in the case of F, I don't think any such order was made, so the obligation would apply directly to F.
Yes.
And would no doubt be complied with through the parents, and that no doubt they took the view that the parents could be relied upon without the necessity of an order to ensure that the child complied with the obligations on
But
it.
it not having been made, there's no mechanism, is there, for the child to apply for an order that he should apply instead to the parent.
Well, that
He's
could
just
that-
stuck with this indefinite rule.
well, that's an application that could have been made on his behalf at the time of sentencing.
Yes, but only at that moment.
At that moment, or if there was a genuine difficulty, there is a provision for subsequent application by the police, so you would have to persuade the police to do that.
Yes, we see that in subsections 4 and 5, don't
Yes.
we? And there's some flexibility in these, because Section 90 allows for them to be withdrawn on the application of various people. The order can be renewed or discharged.
Yes, I was just checking whether there was any temporal limit on going back to the same court that had previously been seized of the matter, but I think there is such a temporal limit in 89(1), when he is before the court referred to. I mean, it may be that that wouldn't operate as an absolute bar in renewing an application to that court in circumstances where the police refused, as it were. In other words, one doesn't treat that temporal limit as an absolute bar against that. But subject to that, it is via the mechanisms in 89, 3 and 4.
What does 20 years before the court mean? Is that at the time of sentencing?
Well, that was the question I was raising,
Yes.
query whether it means at that time and at that time only, so as to impose a temporal limit, or whether it simply means that as long as he is before the court, if I can put it that way. I mean, there may be scope for arguing that. Assume a case, it seems highly unlikely, but assume a hypothetical case where the police unreasonably were refusing in circumstances where it was plainly appropriate for such an order to be made. It might be thought that...
Well, that's very sensible, Mr. Eady, but it doesn't chime with the first impression that one would get.
From the phrase,
Which
when
is
he
when you're
before
before the court, which is sentencing you or dealing with you for the offence. Once that court has dealt with you for the offence, that's normally the end of the matter.
Well, my lady, if that's the right construction of 89.1, then the mechanisms are only through the police 89.3. The police decisions of that kind would themselves presumably be subject to judicial review in the usual way, so that if they acted unreasonably, there would at least be some sort of long stop there. Or you come back and you say this is not sensible or human rights compliant, and so read down 89.1 as a possible construction to allow you to get back before a court.
Well, I'm puzzled by the wording of subsections 4 and 5, because there's sort of initiation of the procedure by the Chief Constable, by complaint or by summary application, and that rather suggests that the individual can be brought back in again if the Chief Constable wants to do this, whereas I rather tended to read before the court as being somebody who was already there under the prosecutor's direction.
4 and 5 envisage you going, I mean, somebody appearing in your jurisdiction, the Chief Constable's jurisdiction, he goes to any court whose commission area includes any part of his police area. So that's the magistrates there, and in Scotland there's the sheriff. So it's not doesn't take you. The Chief Constable's area doesn't need to go to the court, it appears, which imposed the sentence.
I mean, he can get, well, inquiry indeed whether he could. He's got to go to the magistrate's court.
Yeah.
But why is section 90? Well, doesn't section 90 give more flexibility? Doesn't section 90 give the...
91 does do it.
Doesn't section 90 give the offender, at any rate, the opportunity to apply to vary an order made under section 89?
Well, it does, but you've got to have an order first.
Yes.
Right. So one still has the residual problem.
Nobody popped up and said,
Nobody
well, if
popped
you are going to do this, well, you've got no choice to do it, but please make a direction that parents do it instead of kid.
Nobody popped up, whether that was through oversight or whether because it was concluded that the parents acting responsibly could be deemed suitable for ensuring compliance by him. It's not clear, and we simply don't know. There's certainly no reference to consideration of this issue.
Subsection 5 of section 890 gives you the appropriate court means. Court made the direction under 89.1.
The trouble is that subsection 1 only enables you to apply for a variation of an order under section 89.
Right, yeah.
Now, it doesn't enable you to to make an order for the first time under section 89. Perhaps the draftsman didn't think of that. If I were a betting person, I'd say that nobody gave any thought to this at the moment of sentencing F.
Well, my lord, that is an inference which can fairly be drawn from the sentencing right, where there is no reference to it. But query whether...
And such reference as there is, it indicates that they'd got it wrong anyway. Well,
because of the reference to 30
5
months
years.
and the lower period.
Yes.
I'm with you, right. Where were we? We've done travel. We've done the nature of the information under the regime. I'm sorry, it's a rather laborious process, but the nature of the information I've now done. Basic information in 83.5. Travel, you've seen the various provisions. Changes in information. Section 84 on page 85 of tab 68. and that can be taken relatively shortly. In effect, any relevant changes in the details previously notified, including specifically having resided for 7 days or more at a set of premises not previously notified, needs to be provided. See 84(1)(c).
It's not only resided, it's stayed.
Yes, it's designed to ensure that if a person is residing or staying in a place for the qualifying period, then they need to notify that. And the qualifying period you'll see defined in 84(6), in effect 7 days, or a combination of periods amounting to 7 days. And you'll see that this provision, 84(1), is tailored to the slightly different information or the different information provisions which govern Scotland and on the one hand and England, Wales and Northern Ireland on the other, because E, F and G of 84(1) apply only to Scotland. The only regulations that have been made in relation to this section have been made in relation to the Scottish position. If you go over onto page 87, 3 lines up from the bottom, you'll see subordinate legislation. Those regulations are at bundle 9, tab 84. And we don't need to turn them up again, we've been to them already in the context of 83.5, but those ones, in essence, require one to update banking details, debit card, credit card, and so on.
Do you have to notify details of your passport under section 83?
In Scotland, but not in England.
So is little e, does that E to G only apply to Scotland?
Yes. So this is as it were, an updating mirror of the substance of the information provisions that we saw earlier in 83.5. So to the extent that there are differences as between the English regime and the Scottish regime, they are reflected in this updating section. Changes.
Well, so E to F are not in the English section?
No. They apply only in Scotland.
That E to G, I think.
E to G, I mean, sorry.
E to G. I'll double check. I'm pretty certain they apply only to Scotland. Whether they are. They were inserted by the
It looks like it's from page
2006
87.
Scottish Act. Yeah, exactly. I think if one goes, over into the next tab, the answer to that question is the same as it were as in relation to 83. In 69, if you go to three sheets in to tab 69, you'll see a section headed section 84 notification requirements changes. Do you have that in tab 69? It's not the first document, but the second one. And then, as with 83, if you go over the page in footnote 3 this time, you will see the equivalent Scottish provision, or Scottish version of section 84. Footnote 4 tells you the legislative source of that.
The Scottish version was changed in 2006, and the English one in 2008, is that right? Judged by footnote 1, is that right? Over the page.
Yes, there were some changes made in that.
But the 2008 changes added little CA, but not E, F and G.
Exactly.
Is that right?
I think that's the way it works. And you see that if you go back to the previous English version, as it were, very confusingly, page 85, you'll see CA. And then if one goes to the source of
I think
that,
F had a lot of difficulty working with this.
it is complicated, I'm afraid, because you've got two lots of legislation running in parallel with slightly nuanced differences between them. But
But it seems odd that we've got the E, F and G in our
in the English,
England, Wales and Northern Ireland version of the Act, having been inserted
I
by
think
the
it's a
Scottish Act. That must be a
it's a
slip.
mistake by Butterworth, I think.
Yes, they
because
shouldn't do it.
previously, in relation to 83, that's what caused the confusion. In
Yeah.
relation to 83,
Yeah.
you had
Yes.
to go into the equivalent of tab 69 to see the difference.
As one should.
On this occasion, they've actually inserted the Scottish provisions and then a footnote. So it's taken a bit of
Yeah.
working out.
So see, I'm not, which bits of you say are mistaken part of Butterworth?
On page 86 of tab 68, E, F and G.
68, page 86.
What is the position if somebody is resident in England and happens to move up to Scotland? All his reporting is done to the English police station, is it? Or does he got to find a Scottish police station and report to them? I mean,
I'm afraid I don't know the answer to that, but I will find the answer to that. There are provisions, I'm going to come to them in a moment, about the manner of reporting, which lists various local police stations. And there are orders made which tell you which police station you go to if you live in Thames Valley and it's your local police station, the police station is listed. There's the equivalent one for Scotland, a different order with Scottish police stations listed. What I don't know, I'm afraid, off the top of my head, is what happens when you move from one reporting regime to the other. I suspect the position would be that if you go for any length of time and you notify your new address,
become resident in the other
or stay for the 7-day period, then the Scottish regime would apply and the Scottish police station would be the relevant one.
Well, I know the details are not exactly relevant, but it looks as if basically if you're away for 2 long weekends in any year, you have to notify.
Well, because of the
7 days in
provision
any
which says
12
7
months.
days, 2 periods in any 12-month
Yeah.
period. A lady, yes. But I will find out what the position is if your long weekend.
One of them is in Scotland.
There would be a horrific position if you had one long weekend in England and another one in Scotland, I agree. But we will see whether we can, the best we can do on that to clarify it. The danger, of course,
Any infringement involves the commission of an offence, is that right?
yes, there are offences that are set out later on, which I'm going to come to. Yeah, I'm going to come to those.
I'm completely lost. If we goes to tab 69,
Yeah.
page 1, first thing, is that the legislation which is in force at the moment? The version of section 83, yes?
That's the version that's enforced in England.
In England at the moment, yes.
And then if you go to the footnote,
Yeah.
that's
So
the version that's in force in Scotland,
Right, okay. So that's
if that makes sense. And so E, F and G are included in the footnote, i.e. the section as it applies to Scotland,
Yeah.
but not in the version as it applies to England. And the mistake that appears to have been made by the Butterworth
right. And
team is to include E, F and G in the electronic version we saw earlier, and only to give you
But is that not true here too? If you look at the second page, section 83, subsection 5, E, F and G are there. And according to the footnote, at any rate, it says added by the 2008 Act. That would suggest that E, F and G are in England.
But they are in relation to 83,
yes.
but not in relation to 84.
Because 84...
You're looking at section 83, and section 83.5 contains a whole variety of categories of information. The difference in relation to 83 is that there are different sub-paragraphs H and I in Scotland, as one sees from the footnote.
Oh, I see, yes.
You see what I mean?
I beg your pardon,
And
yes,
then
you're
it's
right.
confusing because
I'm sorry,
you go
you're
to
right.
84,
Yes, I'm wrong.
E, F and G
You're
are not
quite
in.
right. I
Does that
beg
make
The
sense?
current version of
beg your pardon.
84 is also to be found for whatever reason, am I right? In tab 69, if one reads on, before the Scottish 84, there's the current English one. Is that right? Which doesn't contain E, F and G.
So this one's right,
This one is right.
yeah.
Is that right?
Your attempt to give us this information in a simple form
It's not working
is
terribly
not
well.
working tremendously well. Understand why.
But the English version of 84
Yes.
does
The
not
correct
contain-
English version of 84 is actually the one you can find in tab 69.
Exactly so.
Yeah.
Exactly so, and that's the error. The error with the one in 68, in tab 68, is that it's got E, F and G, and the only hint you get there and the apply in Scotland is when you go to the footnote, to the amendments pieces. Perhaps the solution is in relation to 83 and 84, go only to tab 69.
That's right. I think so.
Could be easier.
It could.
There's a very cryptic thing on page 2 of the section 84 version after subsection 6. There's a sort of square brackets with nothing in it at all. And it does refer to what's being done in Scotland. So I suppose you just jump down to the Scottish bit and find the answer to what should have been there.
Yeah.
In fairness, you can see how those who prepare these things might have had a little difficulty putting them all together.
Doesn't OPSI get it right?
No, probably.
Not sure, we'd have to check.
It always has a cautionary note that nothing is up to date. And,
I mean, partly because of the complication of tracing through all the provisions, I've sought to summarise the core differences between the regimes. In essence, in 83, you've got a wider category of information you've got to give if you live in Scotland. It includes passports, it includes bank details, debit cards and credit cards. And the only thing to note about 84 and the differences in legislative regime as between Scotland on the one hand, England, Wales, Northern Ireland on the other, is that it tracks that position.
Yes. Well, we're not really concerned with Scotland. We're concerned with this jurisdiction.
Oh, no, neither of these cases are Scottish cases, but that is, it may be of some relevance because England, the United Kingdom, is as it were, a composite body for the purpose of the Strasbourg court. So it may be, at least potentially, if there are differences of regime, that you might get a different answer under the convention as between the two jurisdictions. But I thought it was right, not as it were, to leave you entirely in the dark as to the Scottish position for that reason.
Couldn't have anything much more cryptic than that, could you?
And there was then periodic notification, is section 85. And in essence, the point to note about section 85 is that you are required to renew your notification annually. And the period runs from the date of your last notification. So far as the manner in which the information is to be notified, that's dealt with in sections 87 and 88. You'll see from 87 subsections 1 and subsection 3 that in summary you've got to go to the local police station, give the details orally, and then get a written acknowledgement that you've done so.
And again, there's a different version of 87 for Scotland.
Yes.
And 88.
Do you commit an offence if you don't obtain the notification, or is that a matter for the police?
I'm just checking to see section 91, subsection 1.
Well, section 87.3 simply says any notification must be acknowledged.
Yes.
presumably by the police.
Presumably that's so that the police can't challenge you later and say you didn't do it. Is that right? Is this protection? I mean, does that, we mustn't look back at all the things you've already shown us, but is that what happens every time there's a notification, or is it simply this particular sort of annual bit? I mean, it seems quite sensible that you should have some sort of record.
This applies to all of them. It applies to the beginning as well.
Right, yes.
I think because 83 is the initial notification.
Yes. So in effect, you can demand a receipt.
You can.
So they can't then challenge you and say you never came.
Exactly so. And so as to avoid disputes the other way. If someone's saying, well, I went over and I told them, and there is no record of it.
Yes.
It requires the production of a written record.
Yes.
So to deal with...
But presumably the police keep a database of all these acknowledgements, do they?
I assume they do. I don't know what the practice is. But certainly there would be, in any event, there would be a written document produced. The criminal sanctions are then dealt with in section 91.
Just before you leave this, so you, on 87, subsections 4 and 5 seem to be Scottish. Is that
No,
right?
4 is English
Oh, is it?
and 5, yes, they're English. And then
yeah.
5A, 5B and 5C were inserted by the Scottish legislation and shouldn't be in tab 68 at all. Tab 69 is much more reliable.
Tab 69 is much more reliable, I'm afraid, on this as on all other things.
I see. Yes. Yes, I see. So 4 and 5 were substituted by the 4 and 5A and 5B for Scotland.
In Scotland, 5A, the offender must, if requested to do so by the police officer, allow the officer or person to photograph any part of the offender.
Well, it happens in England too, I
It
think.
happens in England too.
No one is immune.
Photograph any part of it. Or do both of these things.
Where's that?
Yeah.
Where's it?
Yeah, that's 87.4 in England. It's fingerprints, photography, so on. I think again the difference of substance, if any, in Scotland is that you can take physical samples.
So that'd be collecting DNA, presumably.
I hesitate to get into MARPA too early, but it might include that. Certainly physical samples are referred to in 5A.
You take fingerprints in Scotland?
No. They don't seem to rely on fingerprints.
Fingerprints? Fingerprints?
No, it doesn't seem to be anything for
No
it.
fingerprinting? Doesn't seem to be referred to in 5A.
No.
Maybe
What's relevant physical data?
it may be assumed that you've got.
Exactly.
Does that include
Got his
fingerprints?
Relevant physical data would be sufficient to cover it.
You'd imagine if he'd been an offender, they'd have got his fingerprints anyway.
Yeah.
Are subsections 4 and 5 repealed, or are they still extant?
Of section 87
No, yeah, section 87, yeah.
in England.
They're still extant.
They're still extant. Again, if one goes to tab 69 is the...
It's much easier to look
Is
at
the
tab
answer.
69 because that's got the current versions of the English
contrasting with the correct
and
current versions of
contrasting with
Scottish.
the Scots, whereas unfortunately some of the Scots has been incorporated in the 68 version.
I know it's right.
Not your fault, Miss Reedy.
No, but it makes exposition and assistance to try and get you through the complicated provisions that much harder. I probably should have gone to 69 first up.
Are you going at some stage to tell us who has access to all of this information?
My lady, yes, I'm going to come to use and access in a moment. if I may. Just before we get there, the previous regime, again, perhaps one doesn't need to spend too much time on this, but simply to notify you that the previous regime was in the Sex Offences Act 1997, and that came into force on the 1st of September 1997. The relevant provisions of that Act, which are no longer extant, are at Bundle 7, tab 62. It was then amended in the Criminal Justice and Court Services Act of 2000. And the relevant differences between the two regimes are summarised at paragraph 17, I hope conveniently, of our case. I then turn to the question my lady asked, which is to do with the retention and use of this information. As I understand it, at least, this information is held by and visible to the police to whom it is provided. There are some provisions in the legislation which deal with the supply by the police of that information to named governmental bodies. That is under section 94 of the legislation. But so far as that statutory permission is concerned, the structure is this. Section 94(2) permits, in effect, police, that is the bodies referred to at subsection 3, to provide information to the named bodies in subsection 2, in effect some other government departments, but for limited purposes, i.e. for the purpose of prevention, detection, investigation or prosecution of offences under this part, as you see in subsection 2. And there's a further limitation in the final words of subsection 2 for use for the purpose of verifying the information. The purpose of verifying the information, or the concept of verifying information, is defined in subsection 4 of that same section. In effect, it's to ensure that the police are getting accurate information. But you'll see that the government body that gets that information for the purpose of verifying can then check its accuracy, within 94(4)A, and then compile a report of the comparison between the data provided to the police and the data it itself holds.
Is there any provision about what the police can use it for?
Well, I'm going to come to that. If you look down from subsection 4 of 94, you will see that the purpose of subsection 5 appears to be to ensure that if police provide information within this regime, they're not going to be held to be in breach of any, presumably their common law duties in particular. But there's nevertheless a further limit. They can't do anything which breaches the Data Protection Act. See subsection 6. And then subsection 7 has a slightly different purpose, which is to ensure that someone, in summary, doesn't run the argument that Section 94, by prescribing a particular type of use, has covered the field.
When it
So
gives
as-
us some other lurking power.
Yeah, so as to preclude other lurking powers, which I'm going to come to in a second. But that appears to be the purpose of 94.7, to enable, so as to preclude an argument that says this legislation has covered a particular use in the context of this type of information, it's covered the field, and therefore it's implicitly excluded any other common law powers to use the information. But anyway, that's section 94. I'm going to come back to the more general powers in a second. That's section 94 for that specific purpose. And then section 95 deals with the report coming back from the government department, if I can put it that way. And in relation to that, the position is that once the report comes back to the police, it is then generally available to them for use in accordance with their powers to prevent, detect and so on crime, rather more generally.
So does it cover two things, inaccurate information, or is it really designed as a preventative measure to to actually prevent repetition of offending? Is that the real target of all of this?
I think the principal purpose of the initial provision of information by the police is to ensure that the information which it gets is accurate.
Yes. Yes.
That's reflected in the fact that it's for the purpose of prosecution of offences under this part.
Yes.
So it's very much a verification exercise, but then the information that they get back
Yes.
can then be used rather more broadly and sits on their files in the ordinary way, I think is the way it's
But
structured.
there may be a bit of updating too. Addresses, names, if names are changing, that kind of thing would be put into the a part of the reporting mechanism, would it?
I suppose it could be if it was put in if it was put in the report that they were claiming social security or claiming housing benefit or something under a different name.
Yes.
That might well come in as part of the check to ensure that the police have got the accurate name. But the essential purpose of these provisions is to deal with verification, to ensure that the regime is effective.
Yes.
By allowing police to take steps by checking with other government departments that they've got the right information.
But what's really interesting
Is the
are
brighter
whatever
question.
other powers there.
My lady, I'm going to come to that right now. And that was why I drew your attention to 94.7, because it does seem that that is designed for the purpose I indicated. The police have the information which is provided to them, and they can use that information pursuant to their ordinary powers. And as this court will be well aware, police powers in relation to the use of information held by them are constrained both by the common law and by the Human Rights Act. They are also constrained by the Data Protection Act,
Sorry, I missed that.
by the Data Protection
Yes,
Act.
thank you.
So, for example, in relation to common law powers, the information could only be used for a proper police purpose.
Is the information treated as in the possession of the police as a whole? When somebody goes and tells the officer behind the counter a piece of information, does that then put it, as it were, in the possession, that piece of information in the possession of all constables, or the whole of the police, or
Well, my understanding is that it would then be available to the police as a whole.
so they could disseminate it? That officer could disseminate it by way of a database or any other method to any other policeman,
Or
as
it
long
could-
as it was for
Yeah,
a lawful purpose.
A lawful purpose, or it could simply be put on a database which is accessible by various forces. And it was to some extent the problem that we had in the Holly and Jessica, the Sir Michael Bishard's inquiry at state line policing and intelligence being held by one force and the difficulties of transposing information. But the answer to your power question is that the information would be available to the police as a whole, not simply to the local force to whom it is provided.
And is the evidence that all this material is put onto some kind of national database?
My understanding is that it goes onto a national database which is accessible by the police as a whole. But just in terms of the restraints on the police's power, one can break down the analysis into at least two types: retention and use. Both would be constrained by common law powers, the Human Rights Act and the Data Protection Act. But certainly so far as use is concerned, the leading authority is the L case that I know my Lord Hope was in, if you recall, in relation to enhanced criminal records certificates. Because most often on any analysis of the operative restraints on, for example, use by the police of information, the true restraint lies in the principles of Article 8 in the Convention. And by and large, the common law and to some extent the Data Protection Act tend to add little if you can use the information or keep the information compatibly with convention rights. By and large, that is because it's, in summary, necessary for proper police purposes and its use is proportionate and sensible. And if that is the position, you're highly unlikely to be in trouble separately under common law restraints and or under the statutory restraints imposed by the Data Protection Act. And it's for that reason that I said that the best repository, as it were, of the relevant principles that govern and restrain use of information of that kind is the L case. That is at Bundle 4, tab 36. I think the only common members between that committee and this court was Lord Hope, who gave the leading judgment, leading speech. Tab 36. And just very briefly to explain the context which might assist. This was a compatibility challenge to legislation which permitted police, in the context of checks on safety of those working with children, to provide information beyond conviction information, information held on their intelligence files, for example, about individuals. That is the import of the word enhanced in enhanced criminal record certificates. It's an enhanced type of information so as to include intelligence. The relevant statutory provision conferred on the police, in summary, power to include information if the information might be relevant to the check and ought to be included in the certificate. The relevant provision you see in paragraph 10 of the speech of Lord Hope on page 1062, just below the letter D. It was section 1157 of the 1997 Police Act. So you'll see the terms of the provision might be relevant for the purpose described in the statement under subsection 2 and ought to be included in the certificate. And the first conclusion of the House was that Article 8(1) was likely to be engaged, by which Lord Hope, I think, meant interfered. There was an interference with Article 8 by the provision of that information. Not necessarily a breach, but an interference with that. In almost all cases, see in the speech of Lord Hope, paragraph 27, first sentence, and see paragraph 29, second sentence, my Lord Hope says, it seems...
Systematic storing. The systematic storing was the key to all of this, I think, wasn't it?
Yes, my Lord, I think your analysis was rather broader than that, because there was systematic storage followed by provision, and that provision also was provided in the context of a release which might have an effect on employment.
Yes. Yeah.
So I think there were a variety of reasons for concluding, and you'll recall that there was a difference, as it were, between the police, represented by Miss Barton, and the Secretary of State, represented by me. The police were taking the view that the information did not interfere with Article 8 rights, and we took a rather more nuanced position, as you
That was
described.
the debate that we had in S and MARPA about whether simply having stuff
Yes,
engaged Article 8.
my lady, quite so.
I
and
thought it did and the others thought it didn't. Strasbourg agreed with me. Unfortunately, I thought it was all justified, which unfortunately Strasbourg didn't, but there we go.
an entirely accurate
Such
summary
is
of
life.
S and Martha. My lady is right. You were in a minority of one on the interference point, and Strasbourg did indeed agree
But
with you.
we have now moved on and we accept that storing information about people
Interferes with Article 8 rights,
does engage Article 8.
particularly if
Yeah.
there is then use for any particular purpose. So there's no great difficulty about that. And to the same effect on the interference point, see Lord Newburger's speech, paragraph 71. Where he concentrates on the use and release of the information. And the real question that was considered, or the central question that was considered by the committee in L, was whether or not the approach of the Court of Appeal in the X case was defensible. In essence, Lord Wolfe in the X case had said, well, as long as the information might be relevant, which you'll recall was the first part of the relevant statutory provision, then in all cases, or pretty much in all cases, it should be provided, and that won't amount to a violation of Article 8. That won't be an unjustified or disproportionate interference with the Article 8 rights. And again, in short form, the committee's conclusion was that that was not correct, and that more weight needed to be given to the fact of interference in the proportionality exercise, but that the legislation was plainly not incompatible because it contained its second limb and ought to be included, so might be relevant and ought to be included, and the words and ought to be included were plenty wide enough to permit all the various Article 8 analyses that were necessary, including in particular the various assessments as to whether or not, the substantive assessments as to whether or not the provision of that information did strike a correct balance in all the circumstances, and secondly, a procedural element, namely whether or not the person concerned should be given and had been given or might be given an opportunity to say what they wish to say about the information before it was provided. So in the speech of Lord Hope, I hope that reasoning accurately, or that description accurately reflects my Lord's reasoning.
It's really paragraphs 44. 46.
It is. I was going to start with 40. Which is, in effect, to import into the concept of ought to be included the Article 8 analysis. And then 44, as my Lord says. If I could invite you to read, I'm very happy to read them, or you can read them to yourselves, 44, 45, and on the procedural point that I just mentioned, also 46, if you would, but the guts of the reasoning is in those three paragraphs.
And Lord Brown, in paragraph 63, really summarised it very neatly, I think, the combined effect of these points.
Yes. Well, the only other passage I was going to refer you to, at least on the procedural point, to the speech of Lord Newburger at paragraph 82. The reason for taking you to this authority will I hope, be obvious. To some extent, the question whether or not, or the statutory question which arose is on the sidelines, so far as we're concerned. The analysis of the committee was to look at what the ingredients, the necessary ingredients were under Article 8, and then to go from there to the statute and say, is the statute incompatible having regard to the requirements of Article 8? That was in essence the structure of the analysis that the committee undertook. And it's for the requirements of Article 8 that we go to this authority in our present context, because it illustrates that before any information could be used in our context, that use, because the police are public authorities, would have to comply with the Human Rights Act and would therefore have to be a use which was permissible, applying the requirements of Article 8. And we see from the L case that the requirements of Article 8 are not simply, is it a bit relevant? That was the error into which the committee held the Court of Appeal had fallen in the X case. They are more onerous than that. In order to justify use of information, there may be a procedural element. You may need to go back to the individual to check the information to see whether there are things that they want to say about it. But leave that on one side. In any event, the potential user of the information, the public authority user of the information, would need to consider whether its release in the particular circumstances or in the particular context struck a proper and fair balance between the competing interests in play in his particular context.
Did anybody do any consultation before the Rugby League got to know?
I don't know the answer to that. We don't know how they got to know about it in the first place, but I'm not aware that
It was an anonymous tip-off, wasn't it?
Yeah, well, I'm not aware that whether there was consultation or not. I mean, it may well be that the consultation element is of less significance in any event in our case, because the sort of information that one was dealing with in the L case was information where the person concerned was suspected, but was likely not to have been convicted of the relevant underlying conduct. So they might well have had something to say about the underlying conduct. And I suspect it was that probably that, as much as anything, drove the procedural analysis of the committee in the L case, whereas the information here is likely to be considerably more mundane and is likely to not, as it were, to be profitably added to by input from the individual concerned. They might, of course, still have a procedural right. It could be argued out as to whether or not they would have something to say about whether it should be provided as opposed to the content of the information. But certainly those two contexts are different.
But it's interesting that we appear to have no statutory provision dealing with the use, other than the very restricted power to check with government, to check the accuracy, basically. There's no statutory provision otherwise defining or restricting the use to which the police may put this information.
There is no statutory provision of that kind, but that was in large part the reason why I was taking you to the L case, because because the restraints that exist on public authorities are relatively clearly known now. They're relatively well established. The L case is but one in a line of cases which started with a case I did some years ago now called Thorpe, which involved the police giving information to someone at a caravan park over Easter. But a clear line of case law, as my lady will be well aware, is and can properly be sufficient for the purpose of satisfying any in accordance with law requirement, for example, under Article 8, although I recognise that in MARPA there were various references in the context of that scheme to detailed legislative schemes and so on. But the principles which govern and restrain the use of information in the hands of the police in our context are, in my submission, clearly defined now in this line of case law, this case being perhaps, as I described it earlier, the best repository of the relevant principles, but it exists alongside the statutory regime in the Data Protection Act.
It's not saying a lot, is it, to say you've got to, it's got to be a proportionate use.
Well,
I mean, that's not actually telling anybody, it's very much, is it?
my lady, no. But again, one has got to approach that sort of issue by, amongst other things, asking the question: well, what would if you did decide that you were going to set out a detailed legislative scheme or legislative scheme of some kind governing the use generally of this sort of information, what would it look like?
What would you say?
That's at least a relevant question. And once one gets into that territory, inevitably the thought line goes, well, it would have to be expressed at a sufficient level of generality to permit proper police use in a whole wide variety of different circumstances. And once that thought line starts running, one comes very quickly back into the, certainly the older line of Strasbourg authorities, Sunday Times in the United Kingdom, in cases of that kind, which expressly acknowledge, in terms of the in accordance with law requirement under Article 8, that some types of legislation in some contexts have to be expressed at a suitably high level of generality. And in my submission, if one does start down that thought line and tries to kind of design a legislative process or a legislative scheme that would cover all that needed to be covered in terms of permitted use, in my submission, you wouldn't end up with something which looks remarkably different from the principles that you can derive from L and the Data Protection Act regime in any event.
But it does help us in thinking about, because it leads to further things that have an impact on private life. I mean, the not being able to play rugby league example is a helpful thing.
So,
is it really? I'm not making any sort of suggestion as to what I think about this, because I don't know what I think. But is it, in fact, a proportionate response to this particular wrongdoing, an interference with the wrongdoer's private life, to prevent him playing outside school a game which could very well contribute to his actually growing up and turning into a proper, responsible, disciplined member of society?
that is a concern, my lady, if I may say so. I respectfully entirely understand. I think my response to it would, however, be this, that one might have to be a little careful in the analysis to split out provision, retention and subsequent use.
You bet.
The rugby league example posits use. And a part of the reason for taking you to, large part of the reason for taking you to the L case is to illustrate through the use of that case that any use of this information would raise its own discrete Article 8 issues and would have to be justified as an appropriate and proper use. And in those circumstances...
Use by but only by a public authority.
Use by a public authority, yes, by the police.
The facts of the case were quite a lot different from what we're thinking of today, weren't they? I mean, you'll remember that the whole point of the enhanced certificate was that it was something which employers were entitled to request.
Yes.
And the problem for the police was that it didn't stop at criminal convictions, or the problem for the applicant, rather, was it didn't stop there. It was anything that happened to get into police records at all.
Yes.
was open to examination by the police to decide whether or not to release it. And they were provided with a table, which I'm sure you'll remember, which absolutely on the face of it was quite inconsistent with the balance which proportionality requires. It had ticks in boxes which loaded it all in favour of releasing information rather than considering the individual's rights. So there was something very particular to achieve in L related to that. there was no question that the broad idea of allowing prospective employers to know whether there was some relevant information that could affect the employability of the individual was properly to be produced, I should say. It was just how they should go about sifting out the stuff they should release and what they shouldn't. Whereas in this case, at the moment, I'm not quite clear yet as to how the information would actually be used, apart from anonymous tip-ops and things like that, which would be quite improper, what the police would actually be doing with the information. Does it come to this, that they make sure that all police forces know where these individuals are, so that they can trace them at any given time? If an offence is committed, they can see where they were, whether they were in the area, that kind of thing?
They can do that, and there is currently exploration of schemes which would allow release on request if, for example, a member of the community was concerned about attention being paid to their child, whether there might be circumstances in which the police could properly release information into the community in that way.
I don't think in L anybody thought there was any problem about releasing convictions. No. If a prospective employer wanted to know whether an individual was applying for a job had to have a conviction, then that wasn't the issue. It was intelligence. It was information which had never been tested in the court and might be completely malicious or completely false and whatever, yes. And yet that could leak out to the prejudice of the individual.
Yes. But it was for that reason that the court designed the scheme that it did. But all that the court was effectively doing was to say Article 8 applies separately to the release of this information.
That's right.
And that has certain consequences in that different context. I entirely understand it's a different context. They might have included the need to check with the person whether the information was accurate, whether they had anything more to say about it. It might have included, certainly would have included a consideration whether the particular use to which it was proposed to be put would, in the circumstances, be a proportionate one. Even assuming you've given them the procedural opportunity to say anything, it might be that after that the police formed the view that the information was effectively so light, so worthless, so unbased that it wouldn't be proportionate to release it to the individual concerned. But all those points are simply illustrative of the broader point, which is that Article 8 applies to govern and restrain use of information.
Mr. Reedy, what's troubling me about this is it's not clear to me how the answer to these questions, assuming you're quite right about all that, how that helps to decide whether the courts below were right to say that a notification period of an indefinite period, that's say a lifelong obligation, is compatible with the statute, with the convention.
Well, my Lord,
that's the narrow question we're deciding.
You don't think it does?
I don't think it does. No. I'm deploying this, as it were, defensively in order to ensure that no one says, well, you can undermine that scheme, put it in the vernacular. You can't use potential use as a stick with which to beat the information provision itself or the indefinite notification period. I understand that is the nature of the issue. The purpose of these submissions is to indicate that the use raises separate issues, and that the controls that apply at that stage are separate. So one can't, as it were, proceed to a conclusion of disproportionality through the door marked use, if I can put it that way. I'm sorry it's taken a while to do it.
How far do you take that? Do you say we simply disregard the possibility of abuse of the information?
My Lord, my submission would be that you are entitled to proceed on the basis that any use made of this information, and of course there's a causa causans, the information wouldn't be available for use or abuse unless it had been provided and was retained. But my submission would be that you have to proceed on the basis that any use of this information would need to comply, as a separate issue, with Article 8.
But that only applies to use by a public authority.
It applies to a use by a public authority, it does. To restrain that use, because otherwise they're not, subject to the positive obligations, they're not covered directly by the Article 8 obligations. But this information is essentially held by the police, so that isn't an unrealistic starting point, at least, even if it does come out into broader circulation later.
Does it have cross-reference to the DNA type of situation where DNA material is retained and obviously would be available for use in certain situations. I mean, leaving aside the problem about how long it's retained for, which was the subject of a successful challenge, as I understand it, and I haven't studied for some time how the line goes, but the idea that provided the retention is not for an unreasonably long period, it's acceptable to retain the information, and because it is there, to use it if there is a need to do so for the purposes of preventing or detecting crime.
Well, there is some parallel with that situation in the sense that the regime that we're dealing with, for reasons I'll come on to, but the regime that we're dealing with is specifically tailored for that purpose also. And the question is whether it is necessary for that purpose, to retain the information for as long as or for the period set out in the relevant legislation. There is that parallel. And my submission will be that we need to look at S and MARPA rather more carefully, but there is certainly at least that parallel.
Before the police supplied the information to an individual, say a non-state organisation, they need to take into account whether or not they would use it in order to interfere with the person's Article 8 rights, would they not? Because they have to, because the state has to protect the people from having from private individuals who interfere with other people's Article 8 rights. I mean, that's.
My Lord,
that's
I would accept.
analysis.
I would accept that. There are. It was my reference to the positive obligations inherent in Article 8 as well,
exactly.
and that plainly would be a relevant consideration. I mean, there are a variety of ways in which it could be done. I mean, they could ask for undertakings of confidentiality and so on, but that would certainly be a relevant consideration. Maybe just finally on that, I'm not going to take you to it, but all of a piece with the reasoning in L, in my submission, is the Thorpe case, the one I referred to about the provision of information from the Northumbrian Police into the North Wales Police's jurisdiction. That's in Bundle 1 at tab 3. And the relevant passages are at 409F. Very quickly just so I can highlight the relevant bits. Bundle 1 tab 3. The divisional court comprised Lord Bingham and Mr. Justice Buxton, as he then was, and in their judgment, the relevant passages are 409F, summarising the Secretary of State's submissions and indicating in the numbered propositions there set out the restraints which should operate on use of information. Simply as a matter of common law, I think at that stage, this was pre the convention coming into force. And those were broadly accepted by the divisional court, with some additional comments which run down to G on page 410. The first sentence of the final paragraph on page 410, I think, is the relevant section, but indicating that even as a matter of common law, there are serious restraints upon the potential use to which information can be put. And to similar effect, but dealing with the procedural obligation as much as anything, the focus rather shifted between the divisional court and the Court of Appeal. And the Court of Appeal, it was very much on whether or not the individuals concerned should have been given an opportunity, a prior opportunity to comment or feed into the information before it was provided. And 428 under our conclusions is perhaps the relevant passage in relation to that, particularly between B and C. That's all I wish to say about use. the evidence of continuing risk that was before the courts below to come more directly to the nature of the issue we're engaged in. Next, if I may, and the relevant evidence that was before the courts is in the appendix at page 197. And the relevant evidence, there was an exchange of witness statements in effect. It runs from 197 to 222 in the appendix. That's the section that deals with nature of risk and so on. And as I indicated earlier, there was considerably more evidence below, by which I mean more exhibits at least to the evidence. But they were by and large in the form of papers, the content of which is summarised in the witness statement. So it was judged, I think, by all concerned, not necessary to burden you with that underlying material. No doubt it can be provided if you wish to see it, but my submission is at least a sufficient, if brief, set of documentation there. And also, my lady, there appears at least to be a broad measure of agreement on that evidence. And there are perhaps 3 points to make about it. The first is that statistics relating to reconviction rates need to be viewed with a considerable degree of caution. In brief summary, that is for the reasons helpfully summarised in the witness statement, the first witness statement of Miss Cam, paragraphs 6, 7 and 9 on pages 198 to 199. And the short points are that she makes are as the basis for that rather broader proposition about caution required, are that only 20% of sexual offences are reported, possibly less. In the US, figures suggest that in relation to rapes, at least, it's only 1 in 10. See paragraph 6. That successful prosecution rates, even of those offences which are reported, are themselves low. She cites a figure of only 10% of a sample of child abuse reports resulting in conviction, and the same or a lower figure in relation to reports of rapes. See paragraph 7. And finally, under that first proposition, as it were, that the official conviction data in any event underestimated the true extent of offending by a factor of something like 5. See paragraph 9. Secondly, and importantly, as a proposition, sex offenders can and do present a risk of reoffending over many years. That is evident from reconviction data alone, with all the caveats you put in place earlier. Some are reconvicted after a large number of years, 15 years, for example. See paragraph 11 on page 199.
These statistics we were looking at, what are they assuming about reported sexual offences where there are acquittals? I mean, as I read it, it's suggesting that they're wrongful acquittals.
That they are?
Acquittals of individuals who actually perpetrated the offences. 35% of perpetrators were charged and fewer than 10 were convicted.
Are you, my lord, I'm sorry.
I'm looking at page 198, paragraph 7. Just so I understand these statistics.
Does perpetrator mean
Yeah.
person
Perpetrator, well,
accused of perpetrating or
it looks like accused
real
perpetrator.
perpetrator.
Because it's referring to charge and then contrasting it with conviction. But in any event, I mean, perhaps the precise detail of those statistics may not matter as much as the rather more obvious general proposition, which is that you need to view them with some considerable degree of caution, because on any view, a set of conviction figures is likely to represent the tip of a rather larger iceberg. Precisely how much of the iceberg is below the water may not be
Yes, and
as
the
important.
most significant statistic seems to me that 80% of those who experience rape don't report it.
Or perhaps less in the context of an
Yes, or less.
I would admit, I suspect it's probably the lack of reporting as much as anything that feeds into the factor of 5 that's referred to in paragraph 9. But the general point is, in any event, remains. But the second proposition is that sex offenders can present a risk of reoffending for over many years. I've referred you to paragraph 11. One of her exhibits, Miss Cann, was the paper at page 202. And again, I'm not going to trouble you with all of that. It's some fairly dense statistical analysis going on. But I don't know whether my lords and my ladies' copy is complete. Certainly in my version, the odd-numbered pages from 203 onwards have lost a bit on the right-hand side. Maybe that's just a function of me, but we can, I suspect, provide a fuller version. The passages I want to mercifully are all on the even-numbered pages, so I hope won't delay us too long. First, on page 204, sorry, just before one gets there, the page 203, just before the final paragraph, dealing with child molesters, and you'll see the figure of a quarter of all reconvictions of sexual or violent crime presumably occurred between 10 and 31 years after release, so a long period of continuation of risk from that. Over the page on 204, the first full paragraph is certainly worth noting. Again, all these studies are no doubt restrained and constrained by the base information which they're operating under, but they do illustrate the general proposition with some clarity. Page 206, under sexual reconviction in the middle of the page, is a similar point. Final sentence, 18.4% received a reconviction after 10 years or longer. Page 208, the first paragraph, full paragraph below the graph. Perhaps unsurprisingly, it appears that the figures support the proposition that there's a greater risk in the period immediately after release, as it were, but that the risk continues. And then 210, it's perhaps at least worth drawing out a dotted line down the main paragraph on that page. I think the thrust of this paper is not to consider the regime that we're dealing with, but to consider appropriate supervisory periods where there is, as it were, more active engagement with the ex-offender. But nevertheless, the proposition remains about the continuing nature of the risk. That evidence of miscan was then responded to by the claimants in a statement of a psychological report of Miss Chrysati, which begins on page 211, and the relevant paragraph for this second proposition about risk continuing for many years is at paragraph 14. There's a broad measure of agreement. You'll see 5 lines up from the bottom of paragraph 14 on page 216, the reference to the 18.4% figure that we saw earlier. And then that is subject of a rejoinder from Miss Cann in her next witness statement, and the relevant paragraph responding to paragraph 14 is paragraph 6 on page 221. So that's the second proposition. And the third proposition is a rather more amorphous one, which is that it is plainly possible amongst the aficionado to have arguments about whether or not the statistics do or don't show that particular types of people have lower conviction rates. And there is some debate, which I suspect you won't have to engage in to any great extent, as to whether or not, for example, there are lower conviction rates in relation to intrafamilial sex offences, and whether there are lower conviction rates in relation to those who deny offences. And you will have seen from the papers that F, at least, initially and for some considerable period denied the offences, denied it right the way through the trial process up to sentence, and for a considerable part, as we understand it, of his sentence was only halfway through that. The position changed. But it's possible, it appears from these statements, to have a more or less resolvable argument about whether or not particular types of category have lower reconviction rates. But that debate all comes with exactly the same rider that marker I put down in relation to the first of my propositions, which is that the reconviction rates are themselves not perhaps the best indication of capacity to reoffend and risk of reoffending. So the critical proposition of my three is the second one, the length of the period for which the evidence before the court suggested that the risk continued.
Yes, that's one part of the picture. The more elusive part one can illustrate by paragraph 32 of Lord Justice Latham's judgment at page 145. The real question is whether an offender who can clearly demonstrate that he presents no risk or no measurable risk of reoffending should be precluded from obtaining a review. And the big question is there such a person?
Precisely. I mean, that is that is going to be a large section of the submissions that I'm going to make, is that both, with respect to Lord Justice Latham and the Court of Appeal, posit a premise which leads to certain conclusions. Of course, if you assume the accuracy of that premise, certain consequences logically and inevitably follow. But my submission is going to be, on the basis of the material before the courts and the material which currently exists, that that is not a legitimate evidential premise. And indeed, one could go a little further.
So these conclusions that everybody should have an indefinite period.
Well, it might or it might not. I mean, what the position appears to be rather more uncertain than that, by which I mean that there appears to be little reliable data about the extent, how long the risk lasts for. There is some research that exists out there. That research does suggest that risk continues, albeit at a potentially decreasing level, although, and it's a point I'll come back to, there may be fluctuations in risk for obvious reasons over a period of time. But given that uncertainty, I'm not sure it necessarily follows that everyone should be subject to an indefinite period of notification. Parliament is, in my submission, entitled to make judgments that there is a degree, at least, of uncertainty out there, and that those who are, and only those who are at the most serious end of the spectrum, should be subjected to the indefinite period. It doesn't necessarily preclude, logically, the drawing of, as it were, lesser lines, taking some degree of risk, but tailoring and calibrating the scheme so that it reflects the seriousness of the offending. That will be the submission in due course. But the picture which emerges from the evidence is clearly one of persistence of risk and, at the very lowest, the most considerable uncertainty as to whether, in the problem category that we're fundamentally focused on, which is those who've been convicted of serious offences and sentenced to a 30-month period or more, whether or not one can ever reach the position of confidently being able to say there is no risk. And that I'm obviously going to contrast with the weight of the regime and the extent of the interference. But I wanted to take you to the evidence because it is going to be an important part of the submissions that I make in due course, for the reason that my Lord Phillips helpfully prompted me on. My Lords, my Lady, I was then going to move on to the legitimate aims, if I may, of the scheme, and make some short points in relation to that. You'll appreciate at the outset of this section of the submissions that it is sometimes tempting to say, we accept that there's a legitimate aim, let's move on to proportionality, and legitimate aim and the things which underpin it rather get lost in the analysis that follows, which then deeply and fundamentally focuses on the position of the perpetrator rather than the victim. But you will also appreciate that all the points that I'm about to make in relation to legitimate aim feed in my submission to the proportionality exercise, and I'm going to come to describe its nature in a moment. But with that caveat, legitimate aims, the scheme in my submission is an attempt by Parliament to provide adequate protection to the public from the serious harm that can flow from the commission of sexual offences. To that end, the three core stages, or potential stages, of the regime, provision, retention, and, although it raises separate issues for the reasons I indicated earlier, use of information, all aim at assisting prevention of crime, detection of crime, and, probably an aspect of prevention, deterrence of future crime. And it's no accident, one suspects, that both the concepts of protection and prevention feature in the long title to the Act. But we also note that each of those core aims, prevention, detection, deterrence, is consistent with providing the offender with the best possibility of a successful rehabilitation. So we say there is a clear link between the core protective aims of this legislation and the prospect of an offender being successfully rehabilitated. The core aims of this legislation were, we respectfully submit, accurately summarised by, first of all, Lord Turnbull in A and the Scottish Ministers, which is in Bundle 3 at tab 29, the relevant paragraph for this purpose is paragraph 43 on page 14, the page numbers being on the top of the top right-hand corner of the page, of the judgment. Paragraph 43, if I could invite you to read that. To the same, or at least substantially the same effect, is the judgment of Mr. Justice Carr, as he then was, in Gallagher, which is bundle 2, tab 12. And there is a reference in the final sentence of paragraph 19 to the aim of protecting the public and deterring sex offenders from engaging in further criminal behaviour. Last sentence of paragraph 19. And he then returns to the theme in paragraphs 25 and 26. 25 and 26, it's tab 12 in bundle 2. Paragraph 19, final sentence, was the first reference, and the second is to paragraphs 25 and 26, which obviously travel more broadly than legitimate aim, but it may be as well to read them as a piece at this stage. I'm going to have to come back to those, but...
Steve, why does Parliament not have a notification for people who stab, for example? I mean, what is it about sex offences which means that they get this regime when you don't have it for people who stab, for example?
I'm told there may be some notification regimes in relation to some other offences, but I think the thrust of my Lord's question is what makes the sex offence regime special.
If it's all to do with preventing crime and so on, why don't we do it for all sorts of things? Bank robbers, everybody can.
My Lord, I suspect that the answer to that question is because of the sort of expert evidence I took you to earlier on, which is that there are considered to be considerable and perhaps additional risks in relation to this category of offender.
They're more inclined to reoffend, aren't they?
Yes.
I think that's very questionable, because my understanding is that about 60% of those who are imprisoned reoffend within a year. And I suspect statistically one might find that there's a greater proportion of reoffending from non-sex offenders.
There may be a combination of that and the seriousness of the offence which is then committed. I don't know how the other data are put together, whether robbery necessarily leads to robbery, whether there is that degree of coincidence between the subsequent crime and the crime for which one was originally convicted.
Anyone who's seen previous convictions of people who stab and so on sees a terrible, terrible tendency to reoffend in these areas. Maybe dying out at some age, but I mean, a sad rate of repetition.
That may be the distinguishing feature, the statistics of reoffending after an apparently crime-free period of 10 or 15 years.
And the propensity to commit a crime of the same kind.
Of the same kind, yes. Anyway, let's adjourn until 2 o'clock.